Returning to our breaking news from the Federal Court of Appeal, it upheld a ruling today that the Liberal government did not have reasonable grounds to invoke the Emergencies Act 4 years ago to quell protests. For about 3 weeks in early 2022, downtown Ottawa was occupied with protesters, including many in large trucks who blocked the streets around Parliament Hill. The Emergencies Act allowed for temporary measures at the time, like regulating and banning public assemblies and a direction to banks to freeze assets. 2 years ago, a federal court judge ruled the government's decision to invoke the act did not bear the hallmarks of reasonableness, justification, and transparency. Joining me now is Michael Kempa, criminologist and author of The Freedom Convoy, Transporting the Dark Politics of the Far Right Across Canada. Michael, great to talk to you.
Thank you.
You know, we spoke a number of times when I was in Ottawa and about the occupation when it was happening too. There's been a lengthy court process since, since that time 4 years ago. Take me through your reaction to the Court of Appeal's decision today.
Not surprised at all that the Court of Appeal upheld what the federal court said just about a year ago, which is that although the Freedom Convoy devolved into an illegal protest after certain elements had taken it further than perhaps the original organizers and people on the ground had intended. Nevertheless, as inconvenient and as criminal as some of the protest may have been, this did not constitute a national emergency as defined very carefully in the Emergencies Act by reference to the CSIS Act. The government cannot declare emergencies in a fashion different from the way that our intelligence agency CSIS does.
So what's the fallout, then the legal fallout for that, Michael? What does this mean, not necessarily for the process, whether this gets to the Supreme Court or not, but give us a sense, too, of what that will mean legally now as moving forward.
Well, it makes it much clearer that the standards are incredibly high for a government to invoke the Emergencies Act. In particular, some of the actions were always considered to be problematic through all the reviews that we've had. Even when we had an inquiry that originally said that the government was on good legal footing to invoke the Emergencies Act, even that inquiry agreed that things like freezing bank accounts went too far, and that a total ban on all protest, once it had been deemed that there was illegal activity, went too far for infringing on people's charter rights to assembly. What it means is some people may now have grounds to bring forward more effectively lawsuits against the government. And it also will come back to the major point, which everybody has been in agreement, all the experts that have ever spoken on these matters, including at the Commission of Inquiry, and we've submitted submissions to the court, that the Emergencies Act itself is very out of date, drafted in the 1980s, and requires a total overhaul.
Do you expect this to go to the Supreme Court? Will the Supreme Court hear this or not? What do you think?
I think if Justin Trudeau was still Prime Minister, it may go to the Supreme Court. I think the current government might be happy to let things lie where they are. As a sort of constitutional criminologist type scholar, I would love to see it go to the Supreme Court. If for no other reason that a final Supreme Court decision would force the hand of whoever forms government to finally overhaul the Emergencies Act, which is something that many of us, far beyond me, have known was necessary for at least 10 to 15 years.
Michael Kempa, a criminologist at the University of Ottawa. Thanks so much for this today, Michael. Appreciate it.